Clifford Fisher and Company and Clifford Fisher.
All right. So everyone, are we ready to get started?
Yes, Your Honor.
Okay, I've read everything. I asked the parties to provide me a checklist order for each of, there's two different motions for summary judgment for Ted Uzelak and for Larry Teal, correct? That's what we're hearing today?
Yes, Your Honor.
All right, so let's kind of first talk, because we don't have a ton of time for this. It looked like, Ms. Stanton, are you arguing this or is your co-counsel?
I am, Your Honor.
It looked like you guys did not respond to a number of the summary judgment, number of the different causes of action that's the summary judgment was moved on. Is that correct?
I don't think that's correct, but I won't hide the ball. I will tell you that our primary arguments are related to conspiracy about what we believe are Cliff Fisher's breaches of fiduciary duty. So that's our count 2.
Okay.
We have shorter responses on count 1, breach of fiduciary duty by, that would be a duty of Mr. Teal or Mr. Uzelak, fraudulent transfer, and unjust enrichment / constructive trust.
Okay.
And if Your Honor wants at the appropriate time, but I don't want to cut you off, I can focus on just those, however you want to handle it.
I mean, it seemed like from my reading of it is kind of what Ms. Stanton said is the main issue really was involving count 2. I don't know that the rest of these cause of actions really apply to these particular defendants.
I think that's right, and I can address those if you want, Your Honor, the conspiracy claims and the related claims.
Okay. All right, let's go ahead and proceed.
Okay, just again for the record, Alan Lowenson for Teal and Uzelak. I'm not going to repeat the standard for summary judgment because you know it. I'm not going to repeat the background facts because they're there. If you have questions about them, happy to address them because I know we're short on time. So let me address the conspiracy claims both with respect to Teal and Uzelak's traditional motion for summary judgment and separately the no evidence motion, obviously either of which, if granted, would be sufficient to grant the summary judgment. Let's talk about traditional first, conspiracy. And I've got a PowerPoint. And Jennifer, can you go to the PowerPoint on page 40? Can we share the screen, Your Honor?
Yeah, go ahead.
Take just a minute, because in fairness to Jennifer, I jumped ahead a bit.
No problem.
Jennifer, are you able to go to the PowerPoint on elements of conspiracy?
Yes.
Okay.
You say page 40?
40 in the outline, yes.
Oh.
It'll say conspiracy. We're almost there, Your Honor. Go back.
Yep. Here we go.
All right. So, Your Honor, you've got on the screen the elements for civil conspiracy, 5 elements, combination of 2 or more persons. Person will seek to accomplish an object or course of action. Persons reach a meeting of the minds. 1 or more unlawful overt acts are taken in pursuance of the object and damages occur. The 4th element, conspiracy, is a derivative tort because, a defendant's liability for conspiracy, go back, Jennifer, please. A defendant's liability for conspiracy depends upon participation in some underlying tort for which the plaintiff seeks to hold at least one of the named defendants liable. The viability of the claim can be defeated by the failure to establish an underlying tort in several ways. The court grants summary judgment against, Jennifer, next, please. The court grants summary judgment against the claimants on the underlying tort. The claimant fails to plead the underlying tort, or the tort claimant pled does not legally exist. That comes from the West Fork case. The Dallas Court of Appeals explained. Next, please. Regardless of the reason for, Jennifer, the reason for the failure of the underlying tort, there can be no independent liability for civil conspiracy. In the 6th amended petition, plaintiff alleges that defendants conspired to breach fiduciary duties owed to Gale. I've already discussed, we discussed in our motion, but we skipped over for here, that there is no informal fiduciary duty between Teal or Usilac on the one hand and Gale. Thus, there can be no underlying valid claim for breach of fiduciary duty.
But isn't the argument that they conspired with Cliff Fisher?
Well, they made both. So I just wanted to get the Teal and Usilac out of the way. Now I'm going to address the Cliff. Give me 1 second, Your Honor, because I'm jumping around so I don't cover things that we're not specifically dealing with now. So it is true that our traditional motion was only directed to the Teal and Usilac portion of the conspiracy. So you need to go to our no evidence motion as it relates to the remainder. So Jennifer, you would skip ahead, please.
I think that's the same one that you had.
Yeah, that's it. But I just wanted it up while we're talking about no evidence, Your Honor.
Okay.
First of all, she argues in her response that we failed to address her claim of knowingly participating in a breach of fiduciary duty. That claim falls within Gale's conspiracy claim, and we moved for no evidence summary judgment motion on her conspiracy claim. Gale has produced, I'm going to discuss what evidence she does talk about, but let me state initially, she has produced no evidence that at the time of any alleged tortious conduct by Cliff Fisher, the Usilac or Teal, one, knew of a fiduciary relationship between Cliff and Gale arising from the divorce decree, which is what they allege, or knowingly participated in that breach. Now she has sort of a subset of a claim with respect to aiding and abetting breach of fiduciary duty. Texas courts rely on the restatement second of torts in discussing liability for aiding and abetting. There are three distinct types of liability for aiding and abetting. One is assisting or encouraging, two is assisting and participating, and three is concert of action. Each of these require a different level of knowledge, intent, participation, and culpable conduct. It's unclear from the petition which of the theories that she's advancing, but it doesn't matter because she has no evidence of any of them. If you go to the next PowerPoint, Jennifer, that starts out the primary actor. Aiding and abetting in terms of assisting or encouraging requires the actor committed a tort, defendant had knowledge they committed a tort, defendant had the intent to assist the primary actor, defendant gave the primary actor assistance or encouragement, and the defendant's assistance and encouragement was a substantial factor in causing the tort. Here, the primary actor would be Cliff Fisher. Then the second type of aiding and abetting, Jennifer, is the primary actor activity accomplished a tortious result. The defendant provided substantial assistance to the primary actor. The defendant's own conduct, separate from the primary actor, was a breach of duty to the plaintiff, and defendant's participation was a substantial factor. Then we come to the third one. Jennifer, next, please. Aiding and abetting concert of action. You've got to show the defendant and other actor committed an intentional act or were grossly negligent. Tort was a highly dangerous, deviant, or antisocial group.
I'm sorry, can you slow down, Mr. Allen?
I'm sorry. When the judge said he was pressed for time, I was trying to accommodate that. I apologize. The second element is the tort was a highly dangerous, deviant, or antisocial group likely to cause serious death or injury to a person or harm to a large number. Next is the defendant agreed explicitly or tacitly to cooperate in a particular plan to accomplish a particular result. The fourth is the defendant's own conduct was tortious and these are all ands, not ors, the tortious conduct of the defendant and the other actor caused the plaintiff's injury. There is no evidence to support any of these three theories of aiding and abetting and no evidence on the general conspiracy. Let's talk about what the response says. In both responses, Gale has a combined section titled, quote, there are genuine issues of fact regarding Teal, and then she says the same thing about Usilac, involvement in knowing participation, conspiracy, aiding and abetting a breach of fiduciary duty. But as we point out in our reply, Your Honor, in that section, Gale makes a number of statements either that have no factual support in the record or with citation to evidence which doesn't support the statement. Now, it's unclear which of these joint statement elements relate to, but here's what they are. With no citation to any evidentiary support, she says Teal or Usilac was aware of and involved in the actions Cliff took that breached his fiduciary duty to Gail. No evidence, citation to any evidence where she says Cliff, working with Teal and Usilac, used the company to keep money from Gail in violation of the divorce decree and is engaged in self-dealing. No citation to any evidentiary support for Cliff has a duty to keep Gail's money safe and remit her half to her, but instead use the company to hide Gail's money to benefit himself. And no citation to any evidentiary support for the statement that Teal and Usilac knew of and participated in Cliff's actions, both as an executive of the company and as a decision maker in the lawsuit. So stop right there. None of those statements provide evidence in response to a no evidence motion because there's not even any evidentiary support cited in the response. Now, she does make a number of statements that she purports to have evidence, but in fact, she does not. In her response to Usilac's motion, Gail states on page 9, quote, Usilac, as a party of the divorce proceedings, knew of the decree of the divorce and the requirements of the decree of divorce. She cites to testimony from Cliff's deposition last month, which asked Cliff whether he ever provided a copy of the decree of divorce to Usilac or Teal, and he indicated they may have received a copy in the course of this lawsuit. Then Gail cites the divorce decree, but this is not evidence that Teal or Usilac were aware of it at the time of any alleged tortious conduct or any alleged fiduciary duties arising therefrom. Next, in response to both motions, Gail states, quote, Teal/Usilac was also involved in the decision to prevent Gail from entering the company property and or contacting clients or prospective clients. Gail cites to a number of excerpts from Cliff's deposition, none of which support this statement. In fact, the only testimony cited that even comes close, even though it doesn't, relates to questions about who filed the application for a temporary restraining order against Gail, which ultimately, as you know, led to a temporary injunction preventing Gail from entering the company property and contacting customers. Now, Cliff does mistakenly testify the TRO was sought by the company as well as Teal and Usilac, which the court can take judicial notice is not the case. The records reflect that the application was filed by Cliff Fisher and Company, not by Teal or Usilac. Then Gail cites to one email repeatedly in which Cliff asks Usilac and others whether he has anything to add to the proposed TRO. That's the question. But there's no evidence of a response from Usilac or anything else to indicate that he was involved in seeking this TRO. Regardless, the court entered the injunction. It has been upheld on appeal, and therefore it can't be wrongful, if nothing else, under the law of the case doctrine. Then Gail states in her response that major decisions involving this lawsuit are made with Teal, Cliff, and Usilac. The only support for this is Gail cites the testimony from Cliff in which he states that Teal and Usilac are defendants in this action. Okay. And he is not the decision maker for them as to whether this case is settled. Okay. Gail then purports to give an example of a major decision stating, quote, a decision was made to withhold Gail's property in an attempt to force her to settle this lawsuit. Well, putting aside whether settlement discussions are even admissible, putting aside the accuracy of her mischaracterization of the email, again, neither Teal or Usilac or any lawyer representing Teal or Usilac is on this email that Gail says demonstrates their participation in the conduct. Now, that's all that she offers with respect to all of these elements. I'm not going to go back over the elements, but you can see for each of these, there were multiple elements. Example, meeting of the minds. Classic element of conspiracy. There's no evidence to support this. So the bottom line, Your Honor, is with respect to the conspiracy and the subsets of it, there is no evidence submitted, and we're entitled to summary judgment.
All right, Ms. Stanton, response?
Yes, I'm going to share my screen as well.
Okay.
All right. As I said, I am going to focus on the conspiracy claim. You should know, Your Honor, and I'm sure you do know, conspiracy and knowing participation are separate claims. There's a recent Texas Supreme Court case, relatively recent, 2010. Texas Supreme Court decided in ERI Consulting Engineers versus Swinnea that they are separate claims. And in fact, our Exhibit 3
I'm sorry, ma'am, I did not get that case. I did not get that case that you cited.
ERI Consulting versus Swinnea.
Could you spell that?
SWINNEA. And it's 318 Southwest 3rd, 867. And in fact, in Exhibit 3 to our response, there's a Rule 11 agreement kind of confirming and narrowing the claims that are asserted against Mr. Teal and Mr. Uselak between my firm and Mr. Lowensen's firm. And that specifically calls out the separate conspiracy and knowing participation claims. But I do want to focus on those. Know that this claim does not require a finding of a fiduciary duty owed to Gail, my client, by either Mr. Teal or Mr. Uselak. But to get there, we look at the obligations created by the decree of divorce. Very briefly, they all of these that I'm summarizing here involve the company. The company shall be sold. Gail shall remain equal owner of the company. No salary increases. Distributions shall be made in equal portions. Gail's entitled to information. Periodic reports sent to Cliff about the company should be sent to Gail. Gail's most valuable asset is the company. We plan to show the jury that the company is now being controlled by Cliff, Mr. Uselak, and Mr. Teal, this trio. And in effect, the effect of their control is denial of access to information by Gail, information being withheld that other executives in the company, including Cliff, are entitled to and getting without a filter, and distributions being withheld. That the company is doing things to push Gail away from the company and keep her from benefiting from her 50% ownership of the company, her most valuable asset. Now, how does that relate to Mr. Teal and Mr. Uselak? Well, Mr. Uselak is the president of the company. He is high level leader. He drives the vision of the company. These are all things Cliff testified to. And officers of a company are charged with knowledge that the company has to completely comply with Texas law, including orders from Texas courts. And that's in a case we cited in our response, College Park Electricity versus IDE at 15 Tex Civ App 273. Mr. Uselak is a decision maker in this lawsuit, along with Cliff and Mr. Teal. And Mr. Uselak has worked at the company for more than 20 years, along with Cliff and Mr. Teal and my client Gail. We plan to show that as president, Mr. Uselak is an integral part of all of the decisions the company makes. And we show evidence of that through Cliff's depo and plan to show more evidence of that to the jury. Similarly, Larry Teal is a vice president who also directs the actions of the company. So that's their relationship to what's going on. What is it that they're doing? Well, we believe we can show the jury that there was knowing participation, like conspiracy, in Cliff's breaches of duty. Not breaches of duty owed by Mr. Teal and Mr. Uselak to Gail necessarily, but just breaches of Cliff's fiduciary duty to Gail, which has not been contested at this hearing. We think the evidence will show the jury that there was knowing participation, that they worked in concert to remove Gail from the company, to remove her from access to the company, to keep her as far away from the company, what's going on with the company, things that she could know as possible. And also, we will show the jury that Mr. Uselak specifically and Cliff Fisher determined how to best pressure Gail. Maybe so they wouldn't have to sell the company like the divorce decree requires. And this is an email that we cited in our response related to seeking input from Mr. Uselak about the things that we should put in the temporary restraining order against my client, Gail Fisher. And how did Mr. Teal and Mr. Uselak benefit from this campaign against Gail? Well, they kept pressure on Gail. Together, this trio kept pressure on Gail to stop the things that the divorce decree required from being fulfilled, to stop the company from being sold, to force a settlement by Gail, to weaken her bargaining position.
Ms. Stanton, one thing that has always confused me about this case, and you're about the definitely not the I can't tell you how many attorneys have represented her, but quite a few over the years. But something I've never understood, but was stated multiple times by one of her prior counsel, and that is there's an order in the family court to sell this company. Yet at least previous counsel always said they had no desire to sell the company. And so this is the first time I've ever heard anyone argue on your side to say that the reason the sale hasn't occurred is because of Uselak, Teal, or Cliff Fisher. And
It's
so
alleged in the
that's,
pleadings.
I'm sorry.
It's alleged in the pleadings, Your Honor.
Okay.
Your Honor, our belief is that it is alleged in the pleadings. We do believe that that's why the company hasn't been sold. And, you know, this was a Solomon-esque decision. Let's split the baby. Let's sell the company. Let's split it in half and sell it, because that's the only thing that seemed to be a workable solution to the family court in this case. And like it or not, that's the order of the court, and that's what has to be done. And Gail is not in a position, she's being kept away from making the decisions to ensure that that's being done. And now it must be done.
What must be done?
The company must be sold.
Right, but that's the family court, not this court.
That is absolutely the family court. But because the company is Gail's most valuable
I guess what, and this is kind of unfair to you because you're brand new here, but this is what we've been dealing with for years. How can you argue now that Uselak and Teal were preventing the sale of the company when prior counsel stated Gail didn't want to sell the company? Now maybe that's your position, but prior counsel specifically said they didn't want to sell the company. So how is that Teal and Uselak's fault if Gail, at least through her counsel, was saying we don't want to sell the company?
Well, I don't think there was ever an agreement by Gail. Let's assume she did. Her counsel did say that. There was never an agreement by Gail. Let's work together and create a legally binding document that keeps us from having to follow the decree of divorce to sell the company. But in this case, you're right, that's the family law case. In this case, what we're saying is the value of the company and everything related to Gail's most valuable asset, the company, her half of the company, all of those things are in the hands of this trio of people. Her ex-husband, Cliff, Larry Teal, and Ted Uselak. All of the control, all of the power is in their hands. And what we're alleging is a conspiracy or knowing participation in a conspiracy to keep Gail from realizing the value of her half of the company, to divert funds into other places. We believe the jury will see that they're doing, things with money that they had never historically done to keep her from getting that they were stopping her from getting information that she sought about the company, to keep her from knowing what was going on and participating, all of these things. And the duty arises by Cliff because he holds something that is owed to Gail. He is her fiduciary with respect to her 50% of the company. He's also her fiduciary because he controls her property, and he's also an agent for her with respect to management of the company. So Cliff has that duty, but what we're getting to, we believe the jury will see how this trio worked together in the boardroom and in the back room to pressure Gail to keep Cliff from having to fulfill his obligations to her in the divorce decree. In short, Mr. Teal and Mr. Uselak are liable if they knowingly participated in the breaches. And knowing participation means, number one, there's a fiduciary duty. That's generally been conceded in this motion, that there's a fiduciary duty by Cliff. There's been no argument that that doesn't exist. That the defendants knew about it. And number three, that the defendants knew the effect of their breach. So did they know about it? Yes. Both Mr. Teal and Mr. Uselak were represented in the divorce proceeding by Mr. Lowenson, the same counsel they have here, and they received copies of the divorce decree as parties to the proceeding. Did they know what they were doing, that they were knowingly participating in it? Yes, they were involved in decisions in this lawsuit. They were involved in high-level management of this company. And all of those things are cited to and attached to summary judgment evidence in the fact section of our response. So if any of Cliff's actions in using the company to withhold distributions or withhold information from Gail are breaches of his duty, then there's an issue of fact as to whether or not Mr. Teal and Mr. Uselak participated in those breaches of duty. And that's the knowing participation claim. We believe that Mr. Teal and Mr. Uselak participated in this, as shown by Cliff's own testimony, saying that they participated in the lawsuit. They made joint decisions regarding seeking the injunctions. They participated in the decision to terminate Gail from the company. And Cliff periodically testified that he sought comments from executives, specifically Mr. Uzelak, regarding things related to the lawsuit, such as the injunction. Briefly on the other claims, breach of fiduciary duty, fraudulent transfer, unjust enrichment, and constructive trust. We do believe that there's a fact issue that Gail is owed a fiduciary duty by
I've read your response in the motion on these other 4 claims. I am going to grant summary judgment. So
Understood, Your Honor.
So let's deal with just the one claim.
Understood.
All right, responding to the conspiracy and aiding and abetting. Anything else that you guys wanted to say?
No, Your Honor, not at this time.
Brief response, Your Honor.
Yes.
I'm going to tell you something you know, but I'm going to say it anyway. Statements by counsel today, statements on a PowerPoint, and allegations and pleadings are not evidence. I have never seen such a clear case of no evidence than with respect to this case. Look at what she told you. She says, well, Cliff did all these horrible things. He withheld information. He withheld distributions. And her only link is to say that Ted Uzelak is a president and he's charged with knowledge. Charged with knowledge is not the test. The test on participation is that he knowingly participated in the breach. There's no evidence of that. Zero. Then
So let me ask this, because we've never really focused on these 2 parties during this case. And so this is kind of a new area. It seems like Uzelak and Teal may be in somewhat different positions here. Uzelak was on the email, kind of the critical email that they're relying on. I don't think Teal was he?
That's correct, Your Honor.
Okay,
It was Mr. Uzelak, the president, on the email.
And then when you were arguing, you were saying that Uzelak, that there was evidence that Fisher regularly consulted with Uzelak, but you didn't say that about Teal. I don't know if that was a misstatement or that was something out of the record.
We do know, and we did cite to deposition testimony where Cliff said he also consulted with Mr. Teal on a regular basis, in addition to Mr. Uzelak.
Your Honor, if I may, obviously, when you have a business that has multiple aspects to that business, and a chairman consults with people who work at the business is not surprising. The question is, did he consult with them and did they participate in his alleged wrongful acts? And there is zero evidence of that. And the email, which you correctly point out didn't relate to Teal, relates to Uzelak, asked him for a response, but there's no indication Uzelak gave a response. So there's no evidence that Uzelak knowingly participated in anything. Second, that anything that he participated in, according to them, was a request to get a TRO, which turned into a temporary injunction, which was upheld by both the trial court and the Court of Appeals as proper. So it can't be a wrongful act that then gives rise, even if they could have shown that they somehow participated in it. The only other thing counsel said is, well, they benefited because money wasn't paid to Gail. Benefit is not the test. There must be affirmative knowing participation in the breach, affirmative action, affirmative meeting of the minds, and it just does not exist for either one of my clients.
I don't know enough about kind of the relationship between Uzelak, Teal, and Fisher. Why was Uzelak on this email and Teal wasn't?
Well, Uzelak lives.
Can you show the email again? Who else is on there were some other people on the email that I didn't recognize.
And while she's getting it, I will tell you the answer, Your Honor. Larry Teal lives in Pennsylvania, isn't at the company offices. Uzelak is in Dallas and works at the company offices. And when they were trying to get the TRO, and Mr. Friedman can speak to this, when they were trying to get the TRO and ultimately the injunction, they were trying to show what Gail's conduct was in the Dallas office. So they were soliciting information.
So who is Alex Gamino and Chris Joyner? Who are they?
So Alex Gamino was an in-house, Seymour, can you help me out?
She is the vice president she's head of the HR department, and Chris Joyner is an executive at the level of Larry Teal, and Ted Uzelak.
And these are all people who work in the Dallas area. So they were, Mr. Roberts, Mr. Friedman were soliciting, and Mr. Fisher information about anybody who would have knowledge that they could use.
So
about
Teal
conduct.
lives in Pennsylvania, but he's the vice chair of the company. Is that right?
Yes, Your Honor, they have work all over the country. It's not just in Dallas, but the offices, the central offices are here in Dallas. And that's where Ms. Fisher was coming in, threatening to blow up the company and kill. And so they were soliciting people who might have factual knowledge. But that's not, first of all, there's no breach of fiduciary duty by seeking a TRO that's ultimately upheld. And second of all, even if there were, the fact that somebody has sent an email to which there is no response does not evidence some knowing participation in some breach of fiduciary duty. There just simply is no evidence, Your Honor, of conduct by my clients participating in any alleged wrongful act of Cliff Fisher. Thank you, Your Honor.
Stanton.
Yes, briefly, Your Honor. The question is not whether or not the injunction sought was a valid injunction. The question is whether or not this was a meeting of the minds or a knowing participation in an idea that would keep Gail away from the company. Do we have a smoking gun at this point in this case that says, hey, let's all three of us work together to make sure Gail gets as little as she can possibly get, even if we're going to violate the divorce decree, or even if we have to tank the entire value of the company? No, they were smart enough not to put that type of a thing in an email. But that's exactly why these cases end up, generally speaking, with fact issues. We believe we will show, based on the way things played out in this case, that Mr. Teal and Mr. Uzelak specifically were involved in this knowing participation of the breach by Cliff to Gail.
And Your Honor, the last thing I'd say is a statement by counsel when we're at the summary judgment level and discovery is closed, we believe.
I understand the law, Mr. Lewinson.
All right.
Your Honor, I would
This is
just point you to the DeRossi case that we cited, which does show that executives that are involved in the management of a company can have knowing participation just by being involved in the management of the company.
do you want to share screen that case?
Let me see if I have it up.
Because you cited to it a couple times.
Let me just read the site to you or see if I have it up already. Oh,
Mr. Lewinson, are you okay?
Yeah, I was just asking my
Okay.
partner a question.
I
Sorry.
thought you had left. I thought the hearing's not over yet. You need to come back.
No, I'm still here. Of course. You see it?
Can you show me a little more about it?
45 is.
Okay, can you show me a little more? Keep going down. Keep going down. Keep going down. Keep going down. Go down to where it talks about aiding and abetting. Okay. Keep going down. Where does it talk about the court order creating? Oh, is it the TSA? Is that it? No.
The court order case was the College Park.
Oh, I'm sorry. I thought this was the court order case.
That's all right. That's the, it's 40 Southwest 64.
Okay. Can you pull it up?
Texas has adopted the concept that corporations, which can, and I guess LLCs and others, because of the fact that they can become dangerous to the state government, that they are always subject to the state and the control of the state and the law of the state, including the judge's orders. So
the case that's about the companies have to comply with court orders and the president has to comply with court orders doesn't deal with aiding and abetting.
That's correct.
well,
Two different concepts.
Two different
two different
concepts, two different cases.
but the concept is that all bylaws, all articles of incorporation, all corporations within a state, as Your Honor no doubt knows, and that by instinct would know, are subject to the state laws, including valid court orders. And when a court order says thou shalt distribute equally, then the managers of that company are, as we have said here, charged with knowledge of that, and they have to make sure that that happens. They can't look to their own bylaws or their own articles of incorporation and say, oh, well, we can turn a blind eye to what the family court said, particularly when their own lawyer was involved in the negotiation and the order that came out that stated that there was equality in the distributions.
Your Honor, there is zero evidence in this record that Mr. Teal or Mr. Uzelak played any role in determining or control over the distributions that were to be paid to Gale. The only evidence they submitted is that Cliff made the decisions regarding distributions, and he didn't allegedly pay Gale what she was due. The fact that somebody is in the management of an entity doesn't mean they control all the decisions of that entity. And they have got to show, for instance, in that case, Darcy or whatever it was, in that case, it showed that he was not just part of management, he was actually involved in the relevant operations and actions that were alleged to have been wrongful. Nowhere is there any evidence in this record that either Teal or Uzelak did any of that or
They're
had
on the
that
board.
responsibility.
They're on the board of directors of the company. They vote for the distributions.
Well, first of all, Your Honor, hang on a second. I don't know how many people I'm arguing against here, but I'll go ahead and respond to Mr. Lynn. First of all, Mr. Uzelak was not on the board, never was, and there's no evidence that he was here. Number two, the fact that Teal is on the board, it is not the board that makes the
It's not on the board.
Who said that?
I think Cliff Fisher was, one of the
Well,
clients was involved in speaking out.
Actually, Your Honor, there is no evidence that Teal or Uzelak were ever on the board, number one. Number two, there's no evidence in the summary judgment record that the board controlled the decisions that they complain about of Cliff Fisher, hiding information or withholding certain distributions. So the link, if their theory were true, every single officer, every single board of director member would always be liable for breaches of fiduciary duty simply because they were, quote, part of management. That is not the law in this state. They have to show knowing participation by that individual. Being an officer is not knowingly participating in an act that they now allege to be wrongful.
Judge, may I, this is Seymour Roberts, may I make one comment?
Sure.
No, well, may I respond to it? I
No,
apologize.
Mr. Lay, you're not the judge. Let Mr. Roberts speak.
One of the
Sure.
things that I've noticed at this hearing is that Ms. Stanton says, when we get to the point of trial, we're going to show this. When we get to the point of trial, we're going to show that. Well, Judge, as George Allen, the coach of the Redskins, once said, the future is now. We're here at summary judgment. You can't wait to the time of trial to show us this or that. You've got to show it now. And as Mr. Lowenson has pointed out, all we have from Ms. Stanton and Mr. Lynn is what they're going to do. Discovery has closed, Judge. It closed. In fact, discovery closed January 31st of this year. If they don't have anything.
I get that, Mr. Roberts. I'm not relying on what they say they're going to do in the future. I'm relying on what the evidentiary record is before me.
Okay.
So, Ms. Stanton, I'm going to give you kind of one last shot here. Show, other than that one email, is there anything else in the evidentiary record you'd like me to look at?
Sure, Your Honor. In Cliff's deposition, he stated repeatedly the decisions that would be within the control of Mr. Teal and Mr. Uselak. For example, on page 92, he said that, quote unquote, other people would be a decision maker in a lawsuit like this, or whether or not to settle this lawsuit. And it was confirmed that other people referred to Mr. Teal and Mr. Uselak. And many times in his deposition transcript, he gives the same answer, that he makes decisions with the advice and consent of, or with the authority of Mr. Teal and Mr. Uselak weighing in on those
Is there
decisions.
anything
or
in the
making them.
record that indicates that Mr. Fisher consulted with Teal and or Uselak about the decision to make distributions?
I don't have a citation off the top of my head. I can check and see, but I don't have a citation for you on the distributions with Teal and Uselak off the top of my head right now. I can follow
Your
up.
Honor, I'll remind the court that the court-appointed auditor concluded that all the distributions were properly made.
And Your Honor,
That's a separate issue.
number one, there is nothing in the record that says that. Number two, the fact that Mr. Uselak might be consulted about whether to settle this lawsuit is irrelevant. The lawsuit hasn't been settled, so there is no act of settlement. And second of all, an act of settlement cannot be some underlying wrongful act in a lawsuit that is then being settled. So they just don't have the evidence, Judge.
Ms. Stanton, you got one chance to show me the record, and then I'm going to have to rule.
Yes, Your Honor. It's around pages 84, 85, and 91, 92 of
Can you
Mr.
share screen
Fisher's
those for me?
deposition.
Can you share screen this for me?
I don't, sorry, I have them on paper in front of me.
Okay,
It said,
good.
but I can, it's
You got it.
our exhibit 1B is the deposition. And he says he will take, on the vision of the company, he gets input from others, but ultimately they try to get a consensus to drive the vision of the company. And he talked about this consensus idea quite a bit. When asked whose vision was it, he said it's collectively the vision of Chris Joyner and Ted Uselak, and then a new employee named Tobias, and that they would take some input from other leaders of the company as well. Then there was a discussion about if the company were to file a lawsuit, as an example, who would be informed, who would make those decisions. And he said he would make those decisions, or the president, Ted Uselak, would have to make decisions for himself on things that were within his purview. He was not the only decision maker, but that other people, including Mr. Teal and Mr. Uselak, were decision makers on things related to the company.
And Your Honor, obviously, not surprisingly, there is no linking between some quote vision of the company and any of the alleged specific wrongful acts that are alleged against Cliff Fisher. And filing a lawsuit is not one of the alleged wrongful acts. So this evidence does not establish anything relevant to the case.
All right, I'm granting summary judgment on all grounds as to Mr. Teal. As to Mr. Uselak, I'm granting on all grounds except as to the aiding and abetting and conspiracy claim. And I will say this, I think Mr. Friedman raised a good point, which was, how the auditor's report may impact these claims wasn't really raised in the summary judgment one way or the other. And so and then if we go to trial and it turns out there is no evidence, this is something that may get disposed at directed verdict for Uselak, but we'll have to see. So guys, thank you so much, everybody. That's it. I made my ruling. You guys are great lawyers, all of you. Thank you so much. I've signed the order, and you should get it by the end of the day. Thank you so much, guys.
Thank you,
Thank
Judge
you,
Hoffman.
Judge.
Thank you, guys.
We see one.
You're still alive, Judge.
Mr. Goolsby, what are you here for, sir?
Your Honor, I'm here for the 3:45. I'm just on early, so
Okay. we're super tight for time on that. So if you can get your opposing counsel on, I've already read everything. I'm pretty close to ruling on most of it, but we're going to be tight. So if you can get your opposing counsel, it might be in your best interest.
Yes, Your Honor, I'll follow up right away.
Okay. Ms. Rivera, did you get all of the emails for those exhibits?
You know what, Judge? That's a good idea. Let me check. I got exhibit 29 and 1. And then I've got 28, 29, 30. The business records affidavit and the declaration.
You got it. You got
Yes,
everything.
I've got them, Judge. Thank you.
Mr. Polker, are you there? Mr. Goolsby?
Yes, Your
I
Honor.
am here, Your Honor.
And I've just emailed opposing counsel, and I've also tried to call them.
Okay.
And so I'm hoping we can get him in earlier.
I mean, it's not his fault. It just
No.
we're short for time.
Sure thing.
Is that Mr. Troiano?
He is opposing counsel.
Okay, yeah, he's signing on right now. Mr. Troiano,
Good afternoon, Your Honor.
are you here for the 345?
I am, although I'm a silent participant. There will be
Okay, is
another
Mr.
break.
Olds arguing it?
Yes, Your Honor.
Good afternoon, Your Honor.
Your lighting is really bad. It's very hard to see, Mr. Olds. No offense. I mean, it's fine if you to go forward, but just so you know.
I apologize.
It's okay. Just let it, you know.
It's a little bit better.
It's a little better, yeah.
Okay.
Is this everyone we need? Can we get started or do we need to wait?
Everyone's here for plaintiffs.
Everyone's here for the defendants, Your Honor.
Okay. Let's go on the record on DC 21-10024, Sieb versus Sieb Holdings LLC. Council make your appearances.
Your Honor, good afternoon. Edward Goolsby and Kyle Pelker from AZA on behalf of plaintiffs.
Good afternoon, Your Honor. Daniel Olds and Daniel Troiano here on behalf of the defendants.
So I wanted to let you know, I reviewed these motions. We're here on 3 motions to exclude. Is that correct?
There's actually 4, but one was unresponded to. I believe it's because it's an issue that we've dropped the claims. There is a Clay Watkins motion to strike that wasn't responded to. He didn't have any opinions and it's on an issue that was dropped. So I don't even think that's really in controversy anymore.
Is that agreed to then?
That's right.
Okay, then that's
So
not an issue today.
We had expert, I think, White, Francis, and Erickson. Is that right?
That is correct, Your Honor.
That's correct, Your Honor.
So I was mentioning that we are kind of limited for time today. I've reviewed these. Sometimes attorneys really want to argue, even though I've kind of made up my mind, but other times they like to know in advance kind of, hey, how do you want to approach this? So would you guys prefer to just argue and then I can tell you at the end what I'm going to do, or kind of give you some guidance beforehand, so maybe so you could direct your argument to the area I think needs to be directed to?
Your Honor, we would love our argument to assist you. We did file replies today, and I realize it's the day of the hearing. That's going to walk me through what I would argue for Your Honor if you just gave me the floor with no direction. But Your Honor, I'd be inclined to just answer your questions.
Mr. Olds?
I would love to hear the court's feedback and where Your Honor is right now.
I haven't seen the replies because it usually takes at least 24 hours to get to us in advance of the hearing. But my strong inclination, is to deny the motions to exclude as to White and Erickson. I do have some pretty serious concerns about Francis, and so I definitely want to hear argument about that particular expert. You're welcome to argue about the other 2. Maybe there's something I'm missing, but I just don't see, based on the motion and the response, that there's really anything that I don't see a situation where I would strike either of those experts.
Your Honor, I think I'm not going to try to re-argue a point. I think the replies emphasized the burden, that they hadn't added anything and there were certain issues there. But Your Honor, you probably already saw those objections in the original motion. If you're so inclined to rule that way, as to Mr. Francis, in addition to the objections we have, certainly the cumulative component becomes very important. As you have said, we will hear from Ms. White, we will hear from Mr. Erickson. So that certainly makes Mr. Francis all the more cumulative.
That was exactly my thought. And then honestly, I wasn't sure how qualified he was to really testify about the matters in this case. But, I know that experts a lot of times don't want to be struck. And so I have been in situations before and like this, where he seems like kind of a, somewhat cumulative, duplicative experts, where the one side would want to withdraw the expert as opposed to having him struck, then he has to disclose it in all future trials, or frequently has to disclose that. Do you want to just withdraw Francis, or do you want to argue over him?
Your Honor, I do think that his testimony is relevant, so I would appreciate the opportunity to.
Do you want to talk to him first? Do you have the ability to talk to him?
I don't know if Mr. Troiano has his number offhand. Does the court mean right now, or?
Yeah. I mean, because I'm going to rule today, so
Sure.
If he's struck, he's struck, and I'd hate to have that on his record if it's.
Yeah.
Excuse me. I need to go take a quick break. Why don't you, Mr. Troiano, see if you can call him?
Sure. Thank you, Your Honor. Dan, do you have his number offhand?
Okay, guys, I'm back. Did you have a chance to talk to the expert yet?
Thank you, Your Honor. We haven't had a chance to contact him yet. I will say if Your Honor is strongly inclined to exclude Mr. Francis,
I'm not saying it's insurmountable. There may be something I'm missing, but my review of it was, but he seemed very cumulative. He didn't have as much expertise as the other two experts. He didn't seem like he didn't know about USPAP or SSVSs, and that seemed to be kind of a key issue in the case. And maybe I'm missing why he needs to testify exactly.
Okay. Could I
But
provide Your Honor with a couple quick points? And if Your Honor is still not convinced, then we could go ahead and withdraw.
okay, what is that?
The main reason Mr. Francis is there, in addition to Mr. Erickson, is that Mr. Francis has special expertise in banking institutions. And so Brazos National Bank is obviously one of the entities, and that's more his focus. And what his opinion is supposed to be is talking about were the proper factors identified by the valuation analysts, and did those seem to be.
But isn't that something that the other analysts could go, especially the agreed value? I'm getting the name wrong, not auditor, agreed. What? Appraiser. Sorry, I don't know why I was thinking of the auditor, agreed appraiser. Isn't that something that he's going to have to testify about anyway?
I think he's qualified to do that. Mr. Francis was mostly there because of his special expertise with regards to banking. But I understand Your Honor's point, which is I don't think his testimony is absolutely necessary, like say Mr. Erickson. So I think we can go ahead and withdraw him. I think that's fine.
Okay. All right, let's go ahead and get me an order on all of this. Make sure, Mr. Goolsby, if you could prepare the order, make sure it says that this at the beginning, that this hearing was heard on November 28, 2022, that Mr. Old's client voluntarily withdrew Mr. Francis as an expert because however you want to state it. Make sure you share it with Mr. Olds. If possible, it's probably unlikely you could do, well, I guess it doesn't really matter. Just get it to us sometime this week so that we can get the order taken care of, okay?
And Your Honor, on the subject of Mr. Watkins, does Your Honor want us to say that that's been withdrawn as well?
Yeah, I think that's what Mr. Olds said. That's a good point. Mr. Olds.
Okay.
Yeah, that's right.
Okay, and Your Honor had asked us about the special setting for July 11th. Plaintiffs are able to do that. I know you had wanted a response on that. I know the defendants were still checking, but we wanted to let you know plaintiffs are available for that.
Let me see if we still have that.
So, Your Honor, before you do that, I can tell you Ms. White is actually in Europe during those dates, so I'm afraid we can't actually do that date for a special setting.
Okay. What is the status then? Like, have we reset this to July 11th? Is that the deal, or what is the status of the trial sitting right now?
My understanding from the last hearing, and I wasn't at the last hearing, and Mr. Goolsby can correct me if I'm wrong, but my understanding was that Your Honor offered July 11th as a special setting for this trial date, and the respective sides are going to check with their folks and see if they were available and then reconvene. I think there may have been a trial announcement that went out. I'm not quite sure.
Let me see. What's the current trial setting on the case?
It's tomorrow, Your Honor.
Okay.
That was the original.
I mean, if you guys don't agree to something, then we're just gonna set it. It may be a good date or not.
Well, do you have, I guess you had said that July 11th was a special setting. We are interested in doing that if you have any availability, Your Honor, for other special settings besides that date.
Well, it's tough. You said this was gonna be a 2-week trial, right?
I was thinking, Your Honor, it was going to be a 3 to 5 trial days.
I think a 2-week trial is more accurate from our perspective.
Because we do 4 trial days a week.
Okay. I would be surprised if this was 2 weeks, but
let me just try to, I'm gonna give you as many options as you can, but you need to let me, February 7th, I guess we could possibly do. March 21st. I'm just gonna give you every possible date. May 2nd. May 30th. And June 20th. June 11th is just such a good date. So July 11th. August 22nd is really good too, or August 29th. Those would be exceptionally good dates. So why don't you check on those? We just we're going to reset your case tomorrow. So if we don't hear from you by tomorrow, it's just going to be set on a random date.
and Your Honor, just for clarification, were these just regular settings that are available, or would any of them be special settings?
Any of those could be special settings.
Thank you, Your Honor.
But you got to let me know soon, like tomorrow, by tomorrow.
Okay.
Yes, Your Honor.
We'll check with our folks.
All right, guys. Anything else today?
Nothing further from plaintiffs, Your Honor.
Okay. You guys have a great rest of your day.
Thank you. You too.
Thank you.
Judge, I think Tony was gonna hop on at 4.
Okay.
Okay, bye. I'll see you later, Judge. Thank you, Rhonda.
Thank
See
you.
later.
Thank you. Bye-bye.
Do we have a backup case to this one? I know that there was an issue with this number 2 case.
Yes, we got a backup, and they've been called down in county court number 2 on an older case, but I told them unless they were actually called down, they need to let me know. If not, they're expected to be in this court.
Okay.
But yeah, we do have one right behind them if this one doesn't go.
Okay.
That's the Collins versus Lozano case.
Sounds good.
I'll give Tony a call to see if she's signing on.
Okay.
She says she's setting up now.
Okay. Okay, is everyone here that needs to be here? Are we still waiting on anybody?
I think we're waiting on Mike Lyons and Stephen Higdon, Your Honor.
Mr. Lyons is, oh, he's signing on right now. So who are we missing? Mr. Higdon?
Yes, he's trying to sign on, Your Honor. We can start without him if you'd like.
It's up to you guys. It's not quite 4 o'clock yet, so. We're going to start off with arguing the motions and limines, and then we're going to go to the exhibits, and then we'll deal with any other pretrial matters.
Okay.
All right. That's not quite 4.
Afternoon, Judge.
Afternoon. It's been a busy day. I assume you guys are going to trial tomorrow. There's no last minute settlement.
No, Judge. We're really going.
Really going. All right. Let's go on the record on cause number DC 20-17490, Adams v. Vu. Counsel, make your appearances.
Michael Lyons on behalf of the plaintiffs, along with Michael Fetchner and Chris Carr. And I think Stephen Higdon may join us here in just a moment.
Casey came on behalf of the defendant. I have Mr. Shell in the office here with me as well.
Is that everyone?
I believe so.
Okay. So let's first deal with plaintiff's motion in limine. Are there any objections to any plaintiff's motion in limine by the defendants?
Yes, Your Honor. We went through and resolved a number of them today. And Mr. Fetchner, correct me if I'm wrong. With we agreed to number 1.
1 is granted.
With respect to number 2, I think the stipulation was where we can do voir dire on the issue of willful and wanton standard of proof, but there's not going to be any conflating of a higher burden of proof or a higher standard of care. Is that right?
That's right.
Okay. 2 is granted as modified. Number 3.
Number 3, the modification was we are, and I might be wrong on this, that we will elicit testimony about the size of our hospital in comparison to other hospitals around the area that the experts work at. But what we won't say is this is a licensed community hospital by Medicaid or those types of arguments.
Is that agreed?
That's right, Your Honor.
Okay.
Number 4, we just have a disagreement on the issue of explaining further what the testimony was during trial. So for number 4, we just have a disagreement on to that.
So, if I may, Your Honor, number 4 is a request that we sent out an interrogatory asking for, among other people, Terry Tucker's schedule. The hospital provided this sworn interrogatory response in discovery a couple months ago. We noticed, well, first we learned that that was incorrect when the hospital finally produced her time card last month. And then we noticed the corporate representative on this topic, on the interrogatory answers, and the corporate representative was not prepared to provide any information about how they got this answer, why they provided this answer. And so we would ask that they be restricted from changing their testimony around when they said Terry Tucker left, was not on duty anymore.
Yeah, I think that, and here's the issue is the understanding of the interrogatory statement that says, quote, the technician scheduled that day to perform MRIs from 8 a.m. to 5 p.m. and the on-call technician to perform after hours MRI procedures that day was Terry Tucker. And what Ms. Gil testified to was that MRI scans are done from 8 a.m. to 5 p.m. And what I think the misunderstanding is Ms. Tucker was on shift from 6 to 5:30, but scans were only done from 8 a.m. to 5 p.m. per the schedule. So that we want, if they're going to say that that was a false statement, obviously we want to be able to clarify what that statement means.
Well, the statement is plain in the response. It says the technician scheduled that day to perform MRIs from 8 a.m. to 5 p.m. and the on-call technician to perform after hours MRIs was Terry Tucker. On the next page, it has her schedule, and she was scheduled from 6 a.m. to 5:30 p.m. and then she was on call after 5:30 p.m. The reason why this matters is because for a long time in this case, the hospital took the position that Terry Tucker had an hour to return to do the MRI because she was, quote, on call. And they based that on their interrogatory response. We only found out later after they produced the time card that she was not on call when she got the order for the MRI. She was on duty. And so to allow the hospital to now retread what they already swore to and what we already went through almost the entire case believing is true because they swore to it would be unduly prejudicial to plaintiffs.
Was there some kind of discovery you would have done differently if the interrogatory answer would have been correct?
It would have changed several things, including how we deposed her when we took her deposition, but it changed the entire scope of the case because this whole case up until a month ago when they produced this time card was that she was on call. Experts relied on that. In fact, their expert relied on the fact that she was allegedly on call to provide expert testimony. And so for us to not be able to explain why that used to be the belief that it was because the hospital swore to it in their interrogatory would be unduly prejudicial.
Yeah, there's no question that you can impeach them on the interrogatory. You can impeach them on if their experts testified as to that. What I thought you were trying to do is exclude them from saying any explanation for this.
Well, what we would like to do is correct. We don't want them to be able to give an explanation as to why they put that incorrect information. They're just stuck with it. We asked their corporate representative that. We noticed her on that topic and asked her questions about it, and she wasn't able to give an answer.
Well, Your Honor, that's actually not accurate. What she said is they perform scans from 8 a.m. to 5 p.m. That's what she said in her testimony. And that's what the crux of this answer is for scheduled MRIs. The person scheduled to do those MRIs from 8 a.m. to 5 p.m. was Terry Tucker. She was also scheduled to do after hours MRIs. So if they are going to proffer that this was an incorrect or untrue statement, we would like the opportunity to clarify that.
Hey, Judge, can I be heard on this? It is an untrue statement. It's a false statement under oath. Now what they want to do is they want to try to repackage it and sell it as a sleight of hand that, well, we were only doing imaging studies till 5, separating what they've actually said in the interrogatory. So if they wanted to change the interrogatory, there's a vehicle for that. It's to amend the interrogatory and come back and say correctly under oath the answer to the interrogatory, which they never did.
Mr. Lyons, why can't that be dealt with through impeachment?
Well, it can in part, but the bell that can't be unrung are all the depositions that we've taken and all the discovery that we've conducted with both their experts and our experts, with the idea that the hospital has taken the position she never left the hospital and she was on call after 5 p.m. What her time card shows is that, in fact, she was on the clock until 5:30. So I don't disagree with Mr. Campbell. I'm sure they're going to try to offer some type of an explanation, but we shouldn't be precluded from saying exactly what this is. They lied in an interrogatory.
I guess I'm missing something there. I'll go ahead and grant it. You can approach and we can deal with it at trial when I maybe have a better feel for what this is really about. Number 5.
It's, this is a pretty similar issue about they file a motion to exclude our corporate representative from testifying in our case, essentially, basically wanting to only play the corporate rep's deposition. And we haven't filed our response to that motion to exclude that corporate rep, but the issue is she's a witness who, if she needs to correct testimony or clarify testimony, she should be entitled to do that. Otherwise, we're being compelled to sponsor what could be incorrect testimony. And so this motion in limine is completely improper for forcing a witness to not be able to amend their testimony or clarify or even change it. It's certainly up for impeachment, but using a limine to say that no, she can't change her testimony is improper.
Your Honor, this is more related to the motion to exclude Sandy Gill, gets into this. But in short, we noticed Ms. Gill on a number of topics, 10 topics, I believe. The hospital objected to 2 or 3 of them. We tried to ask questions on the remaining topics, and it became very clear that she had not prepared or been prepared to answer questions on those topics. And so we were effectively left with a witness that had not done the research, had not done the work that they're obligated to do whenever they appear for a corporate rep deposition. And we were left with fairly shallow answers. And so to now allow the defendant to take that witness to school, to go back and review the record, to go do the work they should have done before we deposed her is highly prejudicial to the plaintiff. That's what they should have done before they deposed her, not after she's been deposed and when they try to call her to trial.
Your Honor, if I may, there's going to be a vast disagreement on what the topics that were noticed are. The topics that were noticed were 5 sets of policies and procedures, and then a number of areas related to those policies and procedures. Then when we got into the deposition, they tried to cover a whole host of things not covered by those topics. That's what the disagreement is going to be on. There was a intra-deposition hearing held on it with one of the associate judges who compelled the witness to go ahead and testify on those topics and on those questions and give answers. And if Ms. Gill is going to be held to those answers that on topics that she wasn't noticed for, she should have the right to be able to clarify her testimony, testify, and again, they can try to impeach her if her testimony is different.
Your Honor, I'd like to reserve further argument on this for the motion to exclude Ms. Gill because it's better briefed in that motion, and Mr. Lyons is prepared to talk about that.
All right, well, we'll reserve on 5. What's 6? The objection to 6?
I don't believe there's any objection.
Yeah, sorry, I was going through my note. Yeah, I think this one was agreed to.
6 is granted. 7?
7, we had a modification about that this policy, that we'll be able to argue that this policy does not apply to staff, but we will not be offering that this isn't the correct policy or there's another policy. Is that right, Michael?
Yeah, that's correct. Essentially, that this is the hospital's only policy on surgical scheduling, and they are not going to dispute that fact. They are going to argue it only applies to their physicians and not the staff that help get the surgery started. But we're agreeing to modify this. They cannot argue anything other than this is the only hospital surgery scheduling policy.
Okay. 7 is granted as modified.
8 was agreed to.
8 is granted.
9 is agreed to with the modification that should plaintiffs be able to introduce evidence of some sort of the government audit, that we will, of course, elicit testimony regarding the entirety of that audit.
Okay, 9 is granted and modified.
Right, and just to be more clear on that, the agreement is that if we introduce public information, which we have collected public information off the internet, they can introduce public information. Well, the lemonade does not cover public information that is on the internet as well.
10.
10 is agreed to.
Granted.
11 is agreed to.
Granted.
I guess 12, the agreement is subject to the plaintiffs have filed objections in a motion to exclude our exhibits in their entirety, under the claim that they weren't timely proffered, I guess. So 12 might be addressed better when we get to that issue.
Say that again, Mr. Kimball.
Plaintiffs have filed a motion to exclude all of defendants' exhibits. I think part of their argument was that we did not mark and exchange them timely. And other than that issue, 12, we agreed to it that we're not going to bring in any undesignated, unidentified, unmarked exhibits at this point, but subject to that ruling, yeah.
12 is granted.
Uh, 13 is agreed.
13 is granted.
14 is agreed.
Granted.
15 is agreed.
Granted.
16 is agreed and mutual.
That's right.
Granted and mutual.
17 is agreed.
Granted.
To the extent that it may be elicited that at some point in time, not intentionally, that Dr. Vu or Dr. Odedra were defendants in this case.
Well, I think what the agreement was is that if defendants are going to question Dr. Vu or Dr. Odedra, they'll approach if they're going to get into whether or not they used to be defendants in this case.
Right.
Who are the current defendants in the case?
Only
Just the hospital.
So it's Adams, basically Jesse and Richard Adams versus Texas Health Presbyterian Hospital, Flower Mound.
Yes, Your Honor.
That's correct.
If you could get me a corrected style on that for tomorrow, that'd be great.
We'll do that, Your Honor.
19 was agreed.
Hey, what about 18?
Oh, I'm sorry. That was agreed as well.
18 and 19 are granted.
And 20 was agreed.
20 is granted.
And 21 was also agreed.
Granted. All right, let's deal with defendant's motion in limine.
And Your Honor, I'm going to turn it over to Mr. Higdon for the plaintiffs to address those.
All right, any objection to defendant's motion in limine, Mr. Higgins?
There are a few. First, on number one, we have agreed to the extent that we will agree to approach on the DOD documents, which are exhibits 41 and 42, I believe, and that otherwise we did not reach an agreement with respect to this.
Okay. Just tell me what you agreed to so we can go through this a little quicker.
Sure, we agree that we will approach before introducing any evidence with respect to the DOJ investigation.
So just tell me, like, 2 is agreed to, 3 is agreed to, 4 is agreed to. I understand what motions in limine are.
Okay, apologies, Your Honor, I misunderstood the court's question. It's
2 agreed to.
2 is agreed to with the modification that it only applied to the plaintiffs, Jesse and Rich Adams.
Okay, 2 is agreed to as modified. 3.
3, Casey, I'm going to need your help. My notes from this one are slightly ambiguous. I think that we reached agreements, but I can't remember.
The agreement, we reached agreement to the amount, but we're not stipulating the proximate cause aspect, but we stipulate to the amount.
Perfect. 4.
4, we've agreed that we will follow the jury instruction and we will not make an argument that the jury should find evidence or find negligence based on a bad result only, but that we should not be prohibited from arguing that a bad result may be considered.
Okay. 4 is granted as modified. 5.
5, I believe, Casey, we agreed that it's moot.
Yeah, we did.
Okay. 6.
6 is agreed to, provided with the modification that it does not apply to demonstrative exhibits, which the parties have agreed we will show to the other side outside the presence of the jury before it's used with the witness.
All right, 6 is granted as agreed as modified,
7 is agreed.
granted.
I believe 8 is the same with the demonstratives, same stipulation.
Sorry, 8, Casey, 8, the modification is a little different in my notes. 8 does not apply to experts who can rely on medical records that they reviewed that aren't physicians that were parties to the case. But Jesse and Rich Adams won't say that a subsequent treater has told them X, Y, and Z.
That's correct.
Okay. 8 is granted.
9 is agreed to.
9 is granted.
10 is agreed to with the stipulation on the record that we have previously informed the defendants that we've given our experts some additional materials that came in late as discovery has, happened in the 11th hour, and their reliance on that doesn't violate this mill.
10 is granted as modified.
11 is the same stipulation with respect to demonstratives as 6.
All right, 11 is granted as modified.
12 is agreed.
Granted.
13 is similar. We agree that experts can rely on information that they have reviewed in this case, but Jesse and Rich Adams won't introduce statements of what if a subsequent physician that's not a party to this case has told them about anything about the standard of care, et cetera, in this case.
Granted is modified.
14, we agree that we will approach before getting into the DOJ materials.
DOJ materials, is that what you said?
Yes, Your Honor.
Okay. 15.
15 is agreed.
Granted.
16, we have tried to reach an agreement on this, Your Honor, but just can't figure out where the meets and bounds of it are. And so don't want to be disagreeable, but also just don't know
16
where.
is the way it's worded. I don't think there's any way you could enforce that. So 16 is denied. You can object at the time.
Understood.
17 is agreed, Your Honor.
Granted.
18, we can agree that we will not make the argument about jurors using their voice or the verdict as their voice or defining what the community wants until closing argument.
Granted is modified.
There is no 19, so I'm going on to 20. 20 is agreed with the exception of, or with respect to the stipulation concerning they're not going to say that the policies and procedures relating to surgery, there's some other policy and procedure that would then beg the question of, well, where's the policy that we asked for? It goes along with the stipulation that was reached to get the agreement on the similar plaintiff's motion eliminate.
20 is granted as modified.
21 is agreed.
21 is granted.
22 is agreed.
22 is granted.
And I apologize, Your Honor, I'm struggling to read my own handwriting on 23 from our conference.
This was the stipulation or the agreement that we would just prove up the literature per the rules of getting it sponsored by an expert.
Thank you. Yes.
You just
No,
have to, on that, you just have to follow the rules of evidence.
correct.
Anything else?
24 is agreed.
Brandon, 25.
25 is similar to 16. I just struggle with the conspiracy of silence. My understanding is what the real ask is.
25 is denied. You can object at the time.
Okay. 26 is agreed.
Brandon,
27, we were unable to reach agreement on this one. And the essential crux of this is that and
I get
really-
it. 27 is denied.
Okay.
You can object at the time.
28 and 29 are both agreed.
28, 29 are granted.
30, I believe we agreed that it's moot in light of the fact that this happened right before their 50th anniversary, Casey.
Yeah, that, my understanding was that we agreed other than, the fact that this happened on their wedding anniversary, that's certainly an issue that you'll raise. So I thought we modified it to where that would be something that could be covered. But if there's a birthday during trial or something like that, that would still be outside the bounds.
Okay.
Sure, I don't know that there's a birthday during trial, but the anniversary will certainly come in.
31.
31 is,
Do you guys really want this? Wouldn't you want to board ire on this to know who's watched that? I would think you would, but maybe not.
Well, Your Honor, the where this came up is in a trial once one of the attorneys who was part of that litigation board-ired on, I'm one of the lawyers that goes after Dr. Dunch, or elicits that kind of information, and that's what this was.
But wouldn't you want to know if any of the jurors had watched that? I mean, because that's going to change some people's views on doctors, I would think. It's up to you. If you want to do this, I think it's a mistake, but I'll grant it.
Judge, could I just make a comment on that?
Sure.
The reason that it should be denied is their expert testified on behalf of Dr. Dunch. He was the only person that testified that Dr. Dunch didn't breach the standard of care. And so as a part of cross-examination to elicit the bias of their expert, we want to ask him that.
It'd be our position that'd be collateral impeachment, where then we have to try the Dunch case and why he was an expert in that and why his opinions were what they were. That seems to be an irrelevant issue to the issues in this case regarding was there negligence that caused this injury.
It goes to the bias and credibility of this witness that he was willing to get paid money to testify on behalf of Christopher Dunch. And he's now testifying in this case on behalf of the hospital.
I mean, I'm trying to figure out how this would work at trial. I understand why you want to get that in. Because I do share Mr. Campbell's concern. I don't want this to be a whole trial about who Dr. Death is. I mean, a lot of people have heard about Dr. Death and Christopher Dunch, but a lot of people haven't. And so how would you propose?
My proposal would be that it's a cross-examination point and that it shouldn't go beyond that. And it shouldn't, like,
give me an example, because I don't want you to go into like,
sure,
this was a very involved situation involving this, Dr. Dunch and Dr. Dunch.
Yes, I was involved in the case.
I mean, but so going into all of the details about that, I think I agree. problematic.
I don't think anybody should. But I do think, much the same fashion that experts that testify in litigation that are paid experts. I mean, I've had defense lawyers cross-examine my expert and say, well, you've testified in case A, B, and C for this other defendant, and you've testified for this other plaintiff, for this plaintiff's lawyer. It goes to the bias and credibility of this witness. The fact that this guy testified as a standard of care expert for Christopher Dunch, I think it's probative of his bias and his credibility that should be weighed by the jury. And if the jury doesn't know who Chris Dunch is, I think then it's face value. I'm not going to go into it.
But Your Honor, the problem is that then we have to put on trial, well, what extent and what issues were you supportive of? And then we're just trying the Dunch case of, okay, well, Dr. Bagley, what part of his care were you supportive of? And it's just completely irrelevant to this case and what happened here. It's a complete collateral matter.
Well, I would agree to limit it, Judge, so that we can't go into the details of the Christopher Dunch case, so that that's not a concern. But if Dr. Bagley had testified on behalf of THR and other cases, surely I get to bring that up without them relitigating what those cases are.
I'm going to go ahead and deny you can voir dire on this issue, and we'll limit it. I agree. You're going to be on a very tight leash on this, Mr. Lyons. I don't want to go into a lot of detail about it, but we can see that how it could potentially be relevant. And I am going to allow Mr. Campbell and you, Mr. Lyons, to voir dire on who's heard of Dr. Dunch, because that may impact who you want to strike. If you have 6 people who are, intimately familiar with Dr. Dunch and this comes out, obviously that could be problematic. So I will allow you to potentially voir dire and strike witnesses based on that, or not witnesses, jurors. All right, 32.
32 is agreed, Your Honor.
Granted.
33 is agreed, and I'm trying to again decipher my own scribble from the conference, and I apologize. Well, I take it back, Casey. I think we tabled the completion of what the agreement would be, because you would go back and look at the objections to the deposition designations. The issue with this
33 is granted. If they're not properly designated as an expert, they're not going to be allowed to testify. But what is proper designation is going to be an issue, obviously. So 33 is granted. 34.
is similar. We will agree to approach with respect to the DOJ materials concerning the investigation and settlement.
34 is granted.
And we withdrew 35, Your Honor.
35 was withdrawn. All right, let's go ahead and pre-admitted plaintiff's exhibits. Are you offering, so the way I do this, just so you guys know, if you haven't been in my trial in my court before. So it looks like we have plaintiff has exhibits 1 through 155. Are you offering all of those exhibits at this point?
Your Honor, we've reached a stipulation on the past medical expenses, and so we do not intend to add to offer all of the billing records.
Okay.
There is a billing record for the hospital that may become relevant, and that is.
So are you withdrawing some of these exhibits?
Yes, Your Honor.
Okay, so let's just let's go through and figure out what we're going to admit. So pre-admit at least. Are there any objections on the first page, 1 through 7?
No, Your Honor. Our first objections are at number 41, exhibit 41.
All right, 1 through 41 are admitted.
Sorry, Your Honor, 40, 41 is my first objection.
Okay, 1 through 40 are admitted. Okay, what's next?
And as far as admission or no objections, 44 and 45 are not objected to.
44 and 45 are admitted.
48 is not objected to.
48 is admitted.
50 through 57, no objections.
50 through 57 are admitted.
63 through 67, no objection.
63 through 67 are admitted.
And 69 through
92.
92. Yeah, thank you. Are no
60.
objections.
69 through 92 are admitted. Okay.
And then there's at the end 144 through 155.
Were those admitted?
Correct. There's no objections to those.
Wait, 144 or 143?
143. Oh, I'm sorry. You're right.
143 through 155, you said are admitted?
154. Nope,
154.
sorry, 153, Your Honor, I apologize.
153, okay.
Well-
The surgical, okay. Let me make sure we're doing this correctly. 153 is a demonstrative. Are you agreeing to the admission of that demonstrative?
No, I'm not, Your Honor. I read the wrong number. You're correct.
All right, so 1 through 152 are admitted, and then 153, 154, and 125 are demonstratives that are not going to be admitted, correct?
Correct.
All right, let's deal with defendants exhibit list.
So, Your Honor, if I may, briefly, while we're on the plaintiff's exhibit list, none of the objections that they've made were made or filed timely. We had agreed to exchange objections on November 11th, and there was also an agreement to file objections on November 21st. We didn't receive any objections to our exhibits until yesterday. So we've been preparing for trial as though they have not objected to our exhibits and they'll all be admitted. And so we would ask that the court find that these have been waived as it's right to do under Rule 166.
Response.
Yeah, Your Honor, there was clearly a miscommunication. One of the parts of the Rule 11 agreement says that the objections and responses are due today at the very bottom of the Rule 11 agreement. So
Can I see this Rule 11 agreement you're talking about? You want to share screen it?
yeah,
I'll share. So this is it's a little clearer than the actual Rule 11 agreement, which was not very clear. This is the language, though. You see November 8th, we exchanged. November 11th, the parties shall exchange in writing their objections to the opposing parties' proposed exhibits, including under Rule 193.7 and deposition testimony. The defendant actually served written objections to our depot designations, but did not serve objections to our exhibits. We conferred on November 14th, and I informed them that because they had not served their objections, our position would be that they had waived them. They didn't serve objections until yesterday. So that was 2 weeks after I informed them that our position was that they waived. Then on November 21st, there's a requirement that we file our pretrial filings, including Rule 166 D through M, and M included in that is our objections. And so they failed to file their objections again, a second time. We also, in our November 21st pretrial filing, stated that our position, plaintiff's position, was that they had waived their objections. So that was November 21st, and they failed to serve or file any objections again until yesterday, the 27th. So they were put on notice several times as far back as November 11th, and they failed to file or serve any objections until yesterday. So we would ask, this court has the
So,
power
Mr.
to,
Campbell, what is, you said that the deadline was actually today. Where do you get that from? You're muted, Mr. Campbell.
I'm pulling that up. At the end of October, we reached a Rule 11 agreement regarding these deadlines, and we had the
Can I
28th.
just, can I see it so I can know what you're talking
and
about?
all this right here, this line right here, we had agreed would be the deadline to file responses would be today, because the pretrial conference we thought would be the morning of trial tomorrow. The problem is they knew that that did not apply to exhibits, because they served written objections to depot designations on November 11th, which is when they were supposed to serve their written objections to
Let me
exhibits
hear
as
from
well.
Mr. Campbell what his, I don't
Your
know.
Honor,
what he's talking about.
Can I share my screen?
Sure.
Does Your Honor, can you see the agreement here?
Right.
And this was down here, response and objections, if any, shall be filed by November 28th. Now, I agree, there are inconsistencies between what November 21st requires and November 28th. There was obviously a misunderstanding on what that meant. We took that to mean, hey, our objections are due on the 28th, as it says in the agreement. And there were a number of back and forth on this Rule 11.
So I'm not sure that this is the Rule 11 that we agreed to.
You have a signed version of it.
Let me pull that up.
And I'm not, it may be, I just, that language looks different to me.
Mr. Campbell, can you pull it up?
Looking for that, Your Honor, right now.
Your Honor, it's Exhibit C to our motion to pre-admit. I can share it if you like.
Here you go. I've got it, Your Honor, pulled up now.
Okay.
All right. Is it on the screen now?
Yes.
All right. So this is, if any, shall be filed by November 28th. And down here, it's signed by, I believe that's Mr. Fetchner.
That looks like a different thing that you showed us earlier.
Yeah, and if I may point out on this one, which I agree, this is the correct signed one, there's the November 11th date there as well for the court to see, where it says the parties shall exchange in writing their objections to the opposing parties' proposed exhibits. That was November 11th. Actually, they didn't do that. We conferred on the 14th. I told them they were supposed to do that, and they still failed to do it. So they've had our objections to their exhibits for two and a half weeks now. We got theirs yesterday.
Yeah, Mr. Campbell, this looks different than what you just showed me. Was there two different Rule 11s or what is?
When I pulled up earlier, it wasn't the signed one I thought it was, and it was one of the exchanges of what went back and forth, and I received the wrong one, but this was the one that was signed, that we obviously were looking at the objections being due on November 28th. We conferred with Mr. Fetchner on the 11th and told him what our objections were going to be, and but I agree, we didn't send them in writing.
Well, we specifically negotiated, there were several exchanges, and we negotiated to exchange the exhibits on the 11th. That was the agreement. That was also part of the agreed amended scheduling order, was that exhibit objections would be exchanged around that date. We agreed on a specific date later, but it's been agreed to twice by the defendant.
Mr. Campbell, I mean, it does seem pretty, I don't like to be super strict on this stuff, but or reasonably strict on it, but it does say the party shall exchange in writing their objection to the opposing party's proposed exhibits, including objections under Rule 193.7 and deposition testimony. And you agreed to it in the scheduling order, and then you agreed to it again here. And I think you're the one who actually drafted this, right? Because it's your name, right?
Right, Your Honor, this is a copy, a screenshot copy from the other one, but tweaked, correct.
And Your Honor, we moved for pre-admission of our exhibits other than 48 and 49, which we are the ones, the DOJ documents that we agreed we should approach before getting into those.
Right, so for example, the DOJ settlement documents and the DOJ press release on 41 and 42, you're agreeing not to pre-admit those,
That's correct.
but then you want like 43, 46, 47, 49, for example, you want all those to come in because he failed to object.
That's correct. And I'm trying to pull up my list. I'm blocked by the shared screen here, but yes.
Then there's some exhibits later, like the medical billing you don't want to have come in, correct?
That's correct, Your Honor.
Mr. Campbell, I mean, my suggestion at this point would be maybe you guys talk and try to work it out and see if there's anything you really need to kind of, what is it, die on that hill for? Is that how the saying goes? That are extremely important that you think you need to object to. Maybe we can reserve a couple of those objections, but they do seem like your objections are untimely.
Okay, well, we can confer on that.
And I think that's what led us to withholding 48 and 49 is recognition that those may be those.
I think you're talking about 41 and 42.
41, 42, you're right.
Okay, why don't you guys confer a little bit more on those? How about defendants exhibits? Are there any objection to any defendants exhibits?
There are, Your Honor, and this also sort of dovetails with a broader issue with respect to the defendant's exhibits that forms the basis of our motion to exclude their exhibits.
Okay.
And we're going to get sort of back into the same Rule 11 agreement that Mr. Campbell has up on his screen when we talk about that. So if you see on the screen, there was a November 21st, 2022 deadline for the parties to file their materials and exchange, all of the materials under 166D through M.
So you're moving to exclude all of their exhibits because they didn't do that timely?
Yes, we didn't get marked exhibits in this case. And I will tell you that for the purposes of, as you just said, what do we really want to die on the hill of? I don't think we need to exclude all of their exhibits, but there are some exhibits that we did not see until late Saturday for the first time to actually begin trying to understand what they are. And we're not able to really prepare until, practically speaking, Sunday to even begin addressing what these exhibits were. And I have a specific list of those exhibits in terms of.
So without waiving your right to object to their timeliness, which exhibits can you agree to?
Okay, sorry. We can agree to 13 and 14.
Okay. You can't agree to any of the medical records? Aren't those already pre-admitted? Or aren't those admitted on your side?
They are admitted on our side, Your Honor. The issue here, and this is where we get to the failure to mark and exchange, is the defendants have also DWQ'd their own set of medical records from lots of these facilities. I don't know what those exhibits actually comprise. I don't know if they intended it for us to be our medical records, which is duplicative of it, or if we got a whole separate set.
Mr.
and
Campbell,
they're-
do you need a separate, I've seen this happen before where what you get from an affidavit service versus what you get from a DWQ service may be slightly different. Is that the issue with these records, or do you even need, are we fighting over something we don't need to fight about?
I think we're fighting over something we don't necessarily need to fight about.
So you don't really need in 1 through 12 because they're already in through the plaintiff, correct?
Correct. The only, I mean, I guess the only issue I have is when in preparing and developing, references for witnesses, we prepared based on our exhibit numbers. But as far as admitting a separate set, that's where
You may have to just modify that and go with the
Okay.
plaintiff's exhibits then.
Understood.
All right, so what else can you agree to? So you've agreed to, you said 14 and 15, the curriculum vitae of Lisa Hepler and Lynn Ray.
So no, 13 and 14.
13 and 14, okay.
I think in view of the court's order with respect to Dr. Ray, I think 15 shouldn't be an issue anymore.
Okay.
Because Dr. Ray is not coming to trial, is my understanding.
Okay.
I don't know that we can lodge objections to 16 through 18. It's just experts in the cases, curriculum vitaes.
All right, 16 through 18 are admitted.
But I guess that's also on the assumption that they're the curriculum vitaes in the case that we've produced and not CVs that they've gathered from other places, because this again gets to we don't know based on what's described here if it's the documents in this litigation or something they pulled from some defense lawyer database or something like that. And that's where we
Are
get
these
into-
your experts or their experts?
Lazar and Shore are our experts, and I have to confess, Your Honor, as the newest comer to the file, I can't say for sure Banathy is our expert or not.
Banathy is plaintiffs.
And
Judge,
I
this-
represent the CVs are all the ones that were produced by plaintiffs. There's no separate.
Okay.
Judge, this is Mike Lyons. If he could unshare his screen for a second. 'Cause
I'm sorry about that.
What I was going to suggest to save time, Judge, if there are medical records that are on our list, we're fine with them. If they're CVs that have been produced in the case, we're fine with them. Let's not spend any time on that. We don't need to worry about that. Maybe we can just categorize.
Then let's move forward.
Yeah.
What else do we got? What else can we agree on?
I mean, I see on their list that they've got some
That-
published peer-reviewed literature on that. I mean, I think the agreement is we're going to lay a foundation for that, right, Casey?
Yeah, exactly.
And they're not ultimately exhibits.
So
Correct.
let's just do this. Why don't you guys just discuss further about this? If there's any additional exhibits, maybe at some point between the plaintiff and the defendant's case, we can talk about what defendant exhibits need to come in. And if you guys want to agree to any additional ones by tomorrow morning, I'll pre-admit those tomorrow morning.
Understood.
Understood.
All
Thank
right.
you, Your Honor.
So you guys have exchanged charges of the court, is that correct?
That's correct, Your Honor.
Have you guys conferred on that?
We have not yet, Your Honor.
Okay. Have you looked to see, is there going to be any major issues in this case about the charge? Usually on medical malpractice cases, there's usually a couple issues, but
I think there is going to be an issue with respect to the number of the blanks, and other than that, I really think based on my review of their charge versus our charge, it comes down to, I think, just the ordering of some of the instructions and where those instructions land in the charge.
okay. So we're gonna, as we go through the trial, we're gonna be conferring, who's gonna be in charge from the plaintiff standpoint on conferring on the charge. And we're gonna have a couple of informal charge conferences. Who's in charge of that for the plaintiffs?
That'll be Stephen.
For
Mr.
the
Higgins.
defendant- For the defendant, Mr. Campbell?
I'll take that, Your Honor.
Okay. All right, any other pretrial deposition transcripts, is that right?
Your Honor,
That's right.
we had another conference on that today, and I have been paring down some of our objections. I think for the sake of the court's time, that's probably something that we can address first thing in the morning, and it shouldn't take too long.
it's got to be quick because we're not going to have a lot. I don't know if you've tried a case lately in Dallas County, but we're getting our jury panels very quickly these days.
Understood.
So, all right. Anything else you guys want to talk about before I let you go?
Judge, we have a motion to exclude Sandy Gill that's pending.
Okay. Go ahead.
So let me tell you what this is, Judge. So we had the hearing on Dr. Ray, and I won't rehash that, but I think that this to some degree is a response to that. So the real issue that you need to decide, Judge, is can a witness who's been previously undisclosed, who has testified under oath that she does not have personal knowledge, a person who their only connection to this case is in October, they designated her as a corporate designee, can she be permitted to be called as a live witness by the defendant that designated her as a corporate designee? And the answer is they should be able to. I don't think the rule permits anything other than allowing a vehicle by which a corporate entity or organization can designate somebody for discovery purposes under 199. What they're now trying to do is repackage a corporate designee, Ms. Gill, who happens to be the chief nursing officer for the hospital. And I get why they're doing it. I think it's in response partly to the ruling regarding Dr. Ray, who was also undesignated timely. So we're asking that the court deny or exclude her as a witness in this case. And there's really three buckets, Judge. I'll be brief because I know it's late. She's never been disclosed in any capacity as a witness in this case, not as an expert, not as a person with knowledge of relevant facts. So from that regard, she shouldn't be permitted. She lacks any personal knowledge, so under the rules, she shouldn't be permitted. And really what this is that it is a designee that was asked to testify who was unprepared. And I know that there's a disagreement about that. Mr. Campbell may see it differently, but from our vantage point, and I'll explain, she was unprepared as a corporate designee on the topics that we asked her to be designated on. And to sort of take that a step farther, we actually had to go call the court. Your Honor wasn't available, so Judge Merritt heard this to compel her to testify on areas that we had previously requested her to be designated on. So let me start with bucket one. I said this earlier. This case has been rocking along for 2.5 years, Judge. And the first time we ever knew of Miss Gill was when she was designated as a corporate designee. She also hasn't been designated under their pretrial order under 166H. They've never told us what the subject matter of her testimony is, and we're on pins and needles. We don't know what it is she's going to testify to. If they want to designate her deposition and bring her by deposition, fine, they're permitted to do that. But now bringing her live is a whole altogether different animal as a corporate designee. Second bucket, Judge, is she's already testified that she's never reviewed the medical chart. She's never talked to any witness. She's never looked at any of the pleadings. She didn't even know what the allegations in this case were. She doesn't know what the hospital staff's training was. She wasn't even employed during the relevant time period that any of the incidents happened. So under 602, she lacks any personal knowledge, and anything she's going to offer would be hearsay from an undesignated. I assume they're going to try to proffer her as an expert, but she's not previously designated. Certainly Rule 199.2 permits you to designate a corporate designee to offer opinion testimony, but it's the opinions of the corporate institution, right? They can offer by preparing her to testify as to positions or opinions that the corporation has about specific identified information in a corporate designee's notice. But here again, we're standing it on its head. They're just trying to bring her affirmatively. So there's no legal support for somebody doing that. Did I lose you, Judge?
I'm sorry. I need to give me 1 second.
Sure, go ahead.
I want So you cited to a rule 199. Give me the rule number again for corporate designees.
It's rule 199.2.
Okay.
In the operative part of the rule, I mean, I don't know how much,
I guess this is the question that comes to mind. I agree with much of what you're saying, especially if she wasn't designated as a person with knowledge of relevant facts. My question is, because I've seen this come up and I've never had anyone argue over it, is you have someone testify as a corporate rep in a deposition, and then if they want to testify about other issues at trial, are they limited to what they were testified in their deposition, or can they testify as to other issues at trial beyond what they were designated in their original corporate rep depot?
I understand your question. So we noticed her both in her individual capacity and as a corporate designee.
Mm-hmm.
Mr. Campbell instructed her not to answer the questions in her individual capacity and objected to her being.
I agree. That's all out. The issue I have is, can she testify as a corporate rep on issues that she was not designated to testify in her deposition? That's what I don't know.
So the answer, Judge, it lies really, there's not a bunch of case law on this issue. I'll tell you, we've looked for the cases. There isn't. But the model to rule 199.2 is 30B6. There's really no material difference between how those two rules are treated. And what the case law interpreting 30B6 says is, we can call her. We can certainly call her if we want to call her because she was designated as a corporate designee. There's no authority for the proposition that a corporation can then go educate this random person on whatever they want to educate her on and then bring her down and have her testify at trial. It's purely a discovery vehicle. But here's the bigger issue for the court. If there's there's procedural reasons for her to be excluded, and I've mentioned those. But probably the most important reason that she should be excluded is the rule says, and there are cases that say this, and I'm just going to read the part of 199.2 that's instructed. In response to a corporate designee request, the organization named in the notice, a reasonable time before the deposition, shall designate one or more individuals to testify on its behalf as set forth for each individual designated the matters on which the individual will testify. And each individual designated must testify as to matters that are known or reasonably available to the organization. Now, when we took her deposition, the hospital took the position that she had some type of constitutional right, a prohibition from being compelled from giving her opinions or her conclusions about whether the hospital had complied with the policies of the hospital. Okay. That's a big issue in this case is, did the employees that were on duty that day, did they comply with hospitals' written protocols, procedures, and policies? And what they said is, well, you can't make her testify to that because that's her own individual intellectual property. But it misunderstands what the whole purpose of the rule is. The rule obligates a conscientious, good faith effort to fully and unevasively answer the topics. And I expect there's going to be a little bit of cat and mouse here about, well, did you properly notice on the topics that you asked? The reality is that we wanted somebody to testify about the policies and procedures. I don't think there's any dispute about that. And when she was asked basic questions like, did the hospital meet the policies and procedures? Should the hospital train their people on the procedures? Should you have adequate staff and adequate equipment in order to meet the policies and procedures? She was shut down and compelled and told not to answer those questions. When we got the court on the phone and the court ordered her to answer, she essentially testified repeatedly, I don't really know because I haven't reviewed any of the facts of this case. I don't have any personal knowledge. I don't even know what the case is about. And so now what they want to do is backfill her and bring her down, I suppose, to be some type of witness in the case. But really what should be the case, Judge, is that they're stuck with their corporate designee's deposition. They had the opportunity to ask questions. They did ask questions. And they should be limited to whatever happened in that deposition. The last thing I'll say is under Rule 215, or maybe is it 212, Rule 215? I see some heads nodding. Okay. Under Rule 215, effectively what happens when you behave this way in a corporate designee's deposition, when you fail to prepare and you fail to answer, is that it's self-sanctioning. They don't get to now come back, as Mr. Campbell said earlier, in correct, incorrect testimony, or I suppose you could do that through an errata sheet, but they haven't done that either. You don't get to now come back and say, I know what I said in my deposition, but now I want to do over. They don't get a second bite. So that's what they're trying to do. They shouldn't be permitted to do it. They should be excluded from bringing her under any number of different reasons, not the least of which is it's self-sanctioning. She didn't answer the questions when she was asked, and we've already been down this road in front of the court. Thank you, Judge.
Campbell.
Yeah, Judge, I'm going to share my screen.
Okay.
You see the following top policies and procedures?
Yeah.
List here. So this is the list of topics that they advised they were seeking a corporate rep on. They identified 5 sets of policies and procedures, and then a number of areas related to those policies and procedures. For example, the first one, the purpose of the identified policies and procedures, the positions and individuals for people developing the above identified policies and procedures, and it goes on. So the topics were these 5 areas of policies and procedures, and then a number of things related to them. That's what she prepared to do. One of the things they were going to ask her was her personal knowledge of the facts of this case and the hospital's performance in accordance with it. She was willing to testify that she wasn't there. She doesn't have personal knowledge, but she has prepared on these policies and procedures as she was noticed. The problem was, and let me see if I can pull this up. She was asked questions like, would it always be inappropriate for licensed hospital personnel aware of the stat order for an MRI to evaluate for an epidural hematoma existed? Would it be always inappropriate for them to clock out and not execute that order without telling anybody else? You know, they're asked questions. She was asked 1,000 questions unrelated to the policies and procedures or the topics identified. And so the purpose of us calling her would be, hey, if the court's going to allow these unnoticed topics and this testimony, and this gets into the expert aspect and the intellectual property that I argued in front of Judge Merritt, was they are forcing her to give testimony on subjects that she wasn't prepared for because they weren't noticed to her, and have asked her to give her expert opinion that she, one, hasn't voluntarily consented to do. It's her intellectual property that she's going to be stuck with this testimony, and she wasn't prepared for it because they didn't properly notice it. So that's why we wanted to have the opportunity to do a full response. We, of course, wouldn't call her until our case in chief next week, and we would get a response on this issue, you know, in the next day or so. We've been busy with other things, but this is a very nuanced issue of what was she noticed on versus what was she actually asked, and then what are they trying to offer to this court, and how those all interrelate. And it's going to require some pretty significant briefing that we just haven't had the opportunity to do yet.
That's fair. I'll let you do a briefing on this and we'll figure it out once we get there. I will say this, that an issue that I want to have briefed, if it hasn't been briefed already, is, you know, what is the, you know, what I asked Mr. Lyons about, which is, you know, you have corporate rep depositions, that happens all the time. You know, we've all been through the arguments about, you know, what is properly been designated, but at trial, you know, do you, I've seen many times where people testify as corporate representatives, usually people with knowledge of relevant facts, but not always. What right do you have, and how are you constrained at trial if you didn't properly designate the individual as a person with knowledge of relevant facts? Is that making sense? Like, can you just have a corporate rep testify about any topic? Can you have them, you know, what is the boundaries for that? I've just never seen that come up before.
Yeah,
it sounds like you, Mr. Lyons, maybe you looked at some cases out of the federal courts on this, but there may not be any Texas cases. So that is an issue. You know, Mr. Campbell, if she does testify, she's going to be very constrained on this. I'm not ruling that she cannot testify because I'm not sure, but if you're trying to, what did you say, backfill it, Mr. Lyons? Is that what the term you said? Backload it, backfill it, something?
Yeah, I mean, I take a different perspective, Judge. Obviously, I'll do whatever the court instructs me to do, but if they're going to bring this person down under the color of authority of the hospital, you know, it's free game. We should be able to ask her whatever we want. It's unconventional. I've never seen it done where the defendant who designates a designee gets to affirmatively call their own person. But yeah, they got disclosure problems. They've got an 801 E2 problem.
Mr. Lyons, I have to admit, I usually see this in commercial cases where this comes up. So I can see maybe this wouldn't come up very often in personal injury cases. It's just not something that people ever argue about. So I don't really know. Can you just bring in somebody to speak on behalf of the corporation at trial? I just haven't, no one has ever brought that issue to my attention. It's kind of an interesting one. So you guys want to brief this more, Mr. Campbell? I think that's perfectly fair. But understand that if you don't brief it, and I've had this happen many times in trial where you say, I'll brief this and you don't brief it. My inclination is probably to not let her testify and just go with the corporal rep deposition. But if you brief it and you can provide some compelling reason why she needs to be able to testify, I'm glad to hear it.
All right, understood, Your Honor.
All right. Anything else, guys?
Judge, what time do you want us in the courtroom tomorrow?
By 9.
And just a housekeeping issue. I anticipate that tomorrow I may have some slides I'd like to use on the PowerPoint on the screen. And will we have access to that?
Mike, you mean for voir dire,
Like from
right?
an AV standpoint?
I'm sorry, I meant for voir dire. I don't know what I said for voir dire.
Let me tell you my view on all this stuff, because I know some judges are different. I'm all about letting you use the AV equipment, letting you try your case. You don't have to exchange PowerPoints in advance. With one major caveat is if an exhibit has not been pre-admitted, you are not to put it into your PowerPoint. So, but any other slides you want to play, that kind of stuff. I know you've probably seen my courtroom before. I don't know that you picked a jury in it, but this is pretty typical of most courtrooms. If you're going to use a PowerPoint during voir dire, you might want to bring in an extra monitor because it's hard for the right side or the defense side of the courtroom to be able to see the screen.
That was my fear. Yep.
And so a lot of people bring in a monitor for that, an extra monitor. But does that answer your question? And how long did y'all want for voir dire? Do you want an hour?
Casey, I think Casey and I have reached an agreement through, I think him and Fechner talked, but are you okay with an hour, Casey?
Yeah, I think that's right.
Okay.
An hour's fine with me.
An hour to each side. Does that work, Judge?
Yeah, that's fine.
Your Honor, there's one other motion pending. We have a motion to compel settlement amounts from the settling defendants for purposes of our settlement credit election. And, you know, we need to make that.
That's something I mean, you're going to have to disclose that, right, Mr. Lyons?
Yeah, so we've argued this many times in Dallas County, and the position that we've always taken is, I think they do get it, but the question is when. And so our preference is we would like to give it to them before the jury is charged.
Okay.
Yeah, the problem for us, Your Honor, is we have a corporate entity that we have to conference with on which election are we going to make. And so giving it to us just before, I don't understand what the harm is in going ahead and giving it to us so that our client can start making that debate.
The election you're talking about as the settlement credit, isn't that come before judgment? That doesn't come before the verdict?
No, that's before the case goes to the jury, Your Honor.
It's slightly different under chapter 74. Casey's right. They get to make an election of whether they want to take the pure comparative fault percentages versus a dollar for dollar credit for any settlement amounts. And so
is that how is that part of the jury charge?
it's not. He gets to make the election beforehand. The jury doesn't know the effect of their answers. Right, Casey?
Yeah, my understanding, I don't have the rule in front of me. My understanding was that we have to make that election prior to impaneling a jury.
My inclination on this, Mr. Lyons, is that you would need to provide it before he starts his case in chief. Mr. Campbell does, but if you want to brief it, that there's some law. I've never had anyone try to argue this, so it's just kind of what seems fair to me is to let him get it right before he starts his case in chief.
If the statute, Casey, if the statute says that you're supposed to have it before we impanel a jury, which I don't remember it saying that, and if it does, fine.
Well, if it does, then yeah, then you would be able to.
We need to give it to you beforehand, but my recollection is it's before the jury is charged. And Judge, there's a reason why we have fought on this issue. It's because insurance companies and adjusters like those that insure this hospital love to make decisions about whether they're going to settle cases based upon this election. And I know that's not likely to happen here, but we just want to, the legislature saw fit to give them this advantage. We want to keep every advantage we possibly can. And there's actually case law to support the proposition that there's nothing discoverable. There's no,
whatever, let me just say, okay, I get what you're saying then. Whatever the deadline is, whether it's right before impaneling the jury or right before the jury is charged, you have to give it to them at least the night before that date.
We'll agree to do that. And Casey, let me know if you've got it in front of you, just ping me. We'll follow the statute.
Okay, I don't have my book with me, but yeah, I'll look at it.
Just to be helpful, if it is at all, what the statute says is that an election under this subsection shall be made by any defendant filing a written election before the issues of the action are submitted to the trier of fact.
Okay.
Which we have always read as when you charge the jury and you submit the case to them.
So we'll give it, unless the court feels differently, we'll give it to them after we've closed our closing arguments.
I would say the night before, but
that's fine. We can do that.
But if Mr. Campbell, you find some contrary law, if Mr. Higdon is incorrect, and it's your recollection is correct, I think you should be able to get it before you have to make that election.
Thank you, Your Honor.
We'll give it to him the night before closing, Judge.
I will see you guys tomorrow.
Your Honor, I've got just a couple more quick things. One is the folks from Court TV have been taking our phone, and so they're curious.
What do y'all think about that? Are you okay with having Court TV?
I don't care.
We filed an objection to that based on, a number of things. One, the president's having an impression on the jury itself that this isn't a high-profile case where seating or occupancy of the court would be an issue that anyone interested could come and view it in trial. The impression that a camera leaves is that this is a substantial case or something outside the evidence. And so from the defendant's position, it offers no benefit to the trier of fact whatsoever and could only pose a risk that it influences them improperly.
I will say this, I'm definitely not going to let them video voir dire or the jury.
My understanding is they don't do that.
But why don't you have them come? My inclination is to let them, but if Mr. Lyons, you're also opposed, then we can tell them no.
Judge, we don't oppose it.
Okay. All right, guys. Anything else?
We had a motion for net worth discovery. We served a topic to their corporate rep before the deposition for net worth discovery. They objected to that, and we were not permitted to go into it. So after her corporate rep depo, we served some written discovery on that issue.
Are we bifurcating this or not?
We are, Your Honor.
So you'll get it after, if you get a finding of liability, then you can have net worth at that point.
Thank you, Your Honor.
Anything else?
Your Honor, Stephen Higdon, hopefully with the last thing so that you don't keep asking that question and someone chimes in, and I apologize. Earlier you mentioned you wanted a updated caption of the case. We actually filed earlier an unopposed motion to restyle the case And then also to limit access to the online docket during the pendency of the case in order to effectuate some of the motions in limine that we agreed to with defendants earlier today.
Limit access to the online, what do you mean?
So the motion to restyle the case obviously eliminates all the references to the other defendants and settling parties, which goes along with the agreements. The agreed motion eliminated with respect to making references to former defendants or settling persons. Or
I get all that, but you said limit access to the online. What does that mean? Like that you want the clerks to seal the case, or what? What do you?
The clerks to limit access to the Dallas County Courts portal to the case file during the pendency of the jury trial, so that the jury can't go home at night. And
I don't know that I'm going to give them a very strong instruction not to do any type of internet research. I go into quite a bit of detail about that. I don't know without a motion to seal under 76A that I can do that, and I would have to do a court order. I don't feel comfortable with that at all. No one has ever asked me to do that. I don't think I can. Unfortunately, the clerk's office doesn't work for me, so they're going to require me to do an order, and then doing that outside of 76A is extremely difficult. So everything else is fine, and I'll give them a very, very strong instruction about not going to do any internet research. I've never had an issue in any case that I'm aware of, at least, where a juror did that. All right, anything else, guys?
Thank you, Judge.
All right, thank you. In fact, I will probably instruct the jury before voir dire about this internet issue, because if you're going to be bringing up Dr. Death, they're going to want to research that online, and I don't want them to do that. So I'm going to make a specific instruction about that. All right, anything else, guys?
Thank you, Judge.
Thank you, guys. We'll see you tomorrow.